You are now tuned in to the latest YouTube channel in the world.
November 19th, 2007. Historic street figure Demetrius Flannery, aka Big Meech, stood in front of the judge. He was here to enter a guilty plea, finally bringing some closure to this battle for his freedom. Over the years, things would be pretty quiet for Meech. That is, until an old friend by the name of Cuffy Gatlin would release court documents accusing Meech of setting him up through a third party by the name of Tammy Cowens. The accusations would seem to fall on deaf ears until the loud voice of 50 Cent echoed them throughout the hip-hop community. Following 50 Cent's explosion, the internet would go into an uproar.
Gang, we in the building today. We got Big Meech. On paperwork, I guess allegedly it's looking like it. I don't know. You know how this AI shit be getting. But check this video out. It's gonna blow y'all mind.
Gang. With many people attempting to decipher whether Meech cooperated or not. Documents would surface proving that Tammy was CS1, the confidential informant who was responsible for initiating the investigation that led to Cuffy's arrest. And Tammy would testify during a suppression hearing that she entered into the informant agreement in order to get a time cut for Demetrius Flannery. Still, there was no documentation other than Tammy's word that she was doing this on Meech's behalf, or was there? In order to truly understand the relationship between Meech and Tammy, you would have to go back before Cuffy's indictment, to the date of Meech entering his guilty plea. During the November 19th plea hearing, the judge would question Meech about the terms of his agreement with the government. The court: have you read the indictment? The defendant: yes. The court: have you discussed with your lawyer the charges, particularly counts 3 and 10, which you intend to plead guilty to? The defendant: yes. The court: in count 3, the offense is continuing criminal enterprise. Do you know what maximum punishment under law is for that? The defendant: yes, life. The court: count 10 is money laundering. Do you know what the maximum punishment under law for that is? The defendant: I think 20. The court: that's right. Has anyone threatened you or forced you to plead guilty? The defendant: no, sir. The court: there has been a plea agreement. Mr. Eisen: on the CCE, Your Honor, there is a mandatory minimum as well. The court: okay, well, I asked him if he understands the maximum under law. There has been a plea agreement between you and the government, right? The defendant: yes. The court: what's your understanding of the agreement? The defendant: that I won't be enhanced. The court: pardon? The defendant: that I couldn't be. The court: well, first of all, what's the sentencing range? The defendant: 30 to life. The court: and on the basis of the guidelines? The defendant: right. The court: that's a recommended? The defendant: right. The court: and that takes into account your criminal history and the nature of your offenses? The defendant: right. The court: and there's a minimum, right? The defendant: 30. The court: 20 years, right? Mr. Eisen, which happens to be the prosecutor: that's by statute, Your Honor. The court: yes, by law. But there's also a provision in the agreement, isn't there, that I can't? At this point, Meech's attorney immediately interjects. As soon as the government begins to talk about the provision and the court begins to talk about the provision, Meech's attorney immediately interjects. He doesn't want that part to go on the record. No, the agreement is that the guidelines are 30 to life, but, and then the judge stopped him and says, let me do it. He said, okay, I'm sorry. Now, it's important to note that during this segment of the hearing, the judge has established that Meech has entered into a plea agreement and that his statutory guidelines range was 30 to life. For those who don't know what a statutory guidelines range is, the United States Federal Sentencing Guidelines are rules published by the United States Sentencing Commission that set out a uniform policy for sentencing individuals and organizations convicted of felonies and serious Class A misdemeanors in the United States federal court system. Now, let's continue.
Okay, gang, this shit getting juicy, ain't it? I bet you 50 Cent sitting back like, oh, wait.
Court. You know that's why I took the job. However, the court must impose a sentence of imprisonment on count 3 of at least 20 years. Mr. Feinberg, yes. The court. That's a provision of the agreement, right? Mr. Feinberg, yes. The defendant on both counts. The court. Well, I understand, but there is a provision that I have to give you at least 20 years. The defendant, right. The court. And if I don't, the government can withdraw from this deal? The defendant, right. Now, right here, the judge has documented another portion of MEECH's plea agreement with the government. So we now know that based on this provision that MEECH has, his guideline range is 30 to life. And there is an agreement with the government that the judge must give him at least 20 years or the government can back out. Let's continue. The court. Okay, when you go to prison, after you get out, there's a period of supervised release. The defendant, yes. The court, right? The defendant, yes. There is also a $200 special assessment, right? The defendant, yes. And I can impose a fine on either count up to $250,000, right? The defendant, yes. And if I let you withdraw your plea for any reason, they can use these statements made here today against you, right? The defendant, I guess, yes. The court, okay. And there is also a forfeiture, but there is nothing specific set forth in the forfeiture, right? The defendant, right. And if I accept this agreement and we go forward, any other charges against you are dismissed, right? The defendant, yes. And if we don't exceed what the agreement says, you have no right to appeal, right? The defendant, right. And if it should turn out that your criminal history is different than that which you have all agreed upon, I can go higher, right? But you can't get out of it. Here, the judge is informing MEECH that if some new information comes out, or if he leaves something out when assisting the probation officer, that the judge can go higher than what the agreed upon max is. MEECH would expose that max with his reaction. The defendant, go higher than what, 30? The court, yeah, I don't know how I can go higher because I think that there is a provision, is there not? Mr. Leibson, who was the other prosecuting attorney, would chime in and say, there is a standard provision, but it's essentially moot. If you don't know what the word moot means in a court of law, an issue or case being moot means that it has...
Gang, me personally, I believe all them cats go to the feds, they come back double agents, for real. Bro.
An issue or case being moot means that it has lost its practical significance because the underlying controversy has been resolved one way or another. So now that we have reviewed the transcripts of the plea hearing, these are the things that we know from MEECH's own acknowledgement. Based on his criminal history points and relevant conduct, his guideline range was 30 to life. He then made an agreement with the government, and based on that agreement, he would plead guilty. And in exchange, the court would not be able to give him less than 20 years, but the government would agree to seek no more than 30 years. We also learned that there is a provision that would allow for MEECH to get more than 30 years, but based on his agreement, that provision was moot. Now let's break down what this means. A guidelines range of 30 to life means MEECH can get no less than 30 years if convicted. By entering into this plea agreement, MEECH was turning his minimum of 30 years into his maximum and lowering his minimum down to 20 years. This signifies that MEECH made an agreement with the government for a downward departure. If you don't know what a downward departure is, a downward departure is when the federal judge imposes a defendant a sentence that is lower than the minimum sentence that was suggested by the sentencing guidelines. Now, not every downward departure is bad. As I just mentioned, it usually happens when a judge deviates from the guidelines because you may have been less involved than others, or may have some special circumstances like a learning disability or something. The judge might just feel the sentence is too steep, but the government agreeing to a downward departure signifies that a defendant has cooperated or assisted them in some way. Before we move forward, I want to demonstrate to you all the types of games that the courts play. If you look at MEECH's actual plea agreement on paper, you will see that there is a difference in the terms that are shown and the terms that were mentioned in the courtroom. The plea agreement actually includes a clause that said it will be void if not signed by March 6th of 2007, but it shows that MEECH didn't sign it until November 14th of 2007. So, the actual plea agreement that you can go look up on the docket is not a true representation of the terms that were presented in the courtroom that day. In fact, if you look at the date of the actual plea hearing, it was 5 days later on November 19th, 2007. They made several oral amendments to the agreement, which they were entitled to do so legally, but by doing it this way, they also ensured that the true details of the agreement would not be in the actual copy that would show up on the docket for the public to view. That still leaves the question of why would the government agree to a downward departure? To find this information out, we have to look at MEECH's sentencing hearing. In a sentencing hearing, both parties get to present evidence. Usually the government will argue why you should get a higher sentence, presenting what we call aggravating factors. On the other hand, the defense will argue for a lower sentence, presenting what we call mitigating factors. In this instance, the government presented no aggravating factors and simply asked that the defendant be placed near his family in Atlanta. In mitigation, the defense would simply argue that MEECH was responsible for getting his brother Terry to plead guilty and that he should get credit for that. The judge would ask, "Are you saying that the government should make a motion for substantial assistance?" To which he responded, "No. Of course, we've seen all along the lengths his attorney has gone through to make sure that no evidence of his cooperating shows up on the paperwork. So his quick denial was expected, but it was still almost like the judge was saying, are you saying that this deal isn't good enough?" Some of you may be sitting here questioning, why would MEECH's attorney feel like he should get a deal for getting his brother to plead out? Well, let's break it down. According to the investigation in this case, MEECH and Terry were identified as the two heads of this organization. During MEECH's plea hearing, not only did he admit to his role, but he also agreed to admit he supervised 5 people named in the conspiracy and that at least 3 transactions he was directly involved in. This meant that 5 people who were under MEECH who had not yet taken plea deals were at risk of having evidence presented that they were identified by MEECH if they went to trial. Among those people who were still waiting to go to trial at the time were MEECH's brother Terry, Wayne Joyner, Brian Garrett, and Kim Williams. Based on MEECH's deal, if T went to trial, MEECH's word could be used against his brother and others. The only way to avoid that was to convince T himself to take a plea deal. By pleading out, T would essentially be incriminating his connect, admitting that whatever they had against him, connecting him to T, was valid. And MEECH's lawyer wanted MEECH to get credit for all of that. The era in which Big MEECH took his plea represents a change of times. Where it was once frowned upon to take a plea deal in conspiracy cases, more and more people started to do it under the premise that they were just taking their own weight. And the government was working diligently to find ways to conceal the fact that this meant they were cooperating. Not just to protect them, but also to keep more people willing to do so. How could one argue that it was wrong when you had certified street bosses like Big MEECH doing it and being allowed to walk the yard of the USP compound openly? See, most people look at plea deals and the first thing they look for in terms of cooperation are Rule 35 motions or 5K1 motions. those are not the only methods of being rewarded for cooperating. One non-traditional way of rewarding cooperation is a Rule 11 C1C plea agreement. Many attorneys recognize and practice this method because it allows them to negotiate a reward with the government. This is a safer method for clients than simply cooperating and leaving it up to the judge whether they did enough to get a Rule 35 or 5K1 motion. And yes, Big Meech did have a Rule 11 C1C plea agreement. Even more telling of the fact that Meech had negotiated a downward departure was the fact that in his pro se 2255 motion filed in 2009, he himself stated that his lawyer had promised him that he would only get 20 years. Meech also took this opportunity to pretty much blame everything that was going on his brother, denying any involvement and saying that if he was guilty of anything, it was just being the brother of Terry Flannery. With a guidelines range of 30 years to life, why would Meech be expecting less than 30? Now, before I move on to Tammy Cowens, I want to say that based on what I see and have here in front of me, Meech had already signed on to be a cooperator in 2007. So for everybody asking where his cooperation agreement is, this is it. The statute governing Meech's plea agreement was Rule 11 C1C. This is not a plea agreement that everybody gets. Meech was given this type of plea agreement as a reward for his cooperation and agreeing to admit specifically to supervising 5 people named in the indictment and to being personally involved in at least 3 transactions. Being in this type of plea gave Meech the leverage to negotiate the life sentence off the table and limiting his sentence to between 20 and 30 years. Because Meech had this plea agreement already locked in since 2007, he didn't have to sign a new agreement or create new terms once Tammy came along. He only had to put her to work. Enter 2012. Big Meech business partner and owner of his life rights, who is also working as a confidential informant, Tammy Cowens, contacts the DEA and informs them of an arrangement that Meech has put together between the individual he was just recently incarcerated with and his longtime friend, Cuffy Gatlin. Cuffy, completely unsuspecting, because he and Meech are friends, and also because the government did such a good job of covering up Meech through the paperwork, indulges. Throughout this arrangement, Tammy is documenting the calls between Cuffy and the other individual so as to add credibility to her information. Cuffy eventually gets indicted, and through litigation, details emerge that the confidential source on Cuffy's case is Tammy. Tammy is now upset with her FBI handlers because they assured her that her name would not be exposed. She contacts Meech and tells him her cover is blown, and he responds by saying he don't want his name in it. Never once reaches out to Cuff to disassociate himself, and never actually cuts Tammy off or reprimanded her for destroying his friendship with Cuff. In retaliation for being exposed, she contacts Cuffy's attorney and tells him that the agents lied in their probable cause affidavits and exposes some of their own underhand practices. Cuffy files a motion to suppress, and all of that information that Tammy possesses comes out on record, and we find ourselves here. I think the biggest lesson to be learned in this situation is that the streets don't love nobody. In my opinion, yes, Meech cooperated and was well aware of what Tammy was doing as well. All of the things he loved about the streets and all of the things he enjoyed ultimately led to his downfall, and his fight for freedom and life probably damaged his relationship with his brother more than we will ever know. He's now fighting to maintain his street reputation, as the clout from that will probably be his only legitimate way to earn income, which is itself a contradiction of everything he preached to his brother in that holding tank the day he told him that he was going to take the government's plea deal. I think Meech should use his platform to talk to troubled kids and explain that just like the Nicky Barnes, Frank Lucases, and all of those guys before him, they too will find themselves in that same position if they pursue a career in the streets. I also hope that this message reaches some of the brothers in the feds, the ones who go hard and stand on business, doing their best to keep the ones with no morals and integrity away. To those brothers, pay attention. Recognize that they are finding new ways to disguise the ones who sent to stir the chaos. I mean, when you look at the grand scheme of things, MEECH was an informant disguised as a real one and was able to get two unsuspecting people who thought they were his friends to believe that they were doing business with him just so he could set them up to get himself out of trouble. That act of treachery is, in my opinion, more evil than the act of selling drugs. It takes a special kind of evil to knowingly set your friends up to lose their freedom for life just to gain your own when they had no fault in your current situation at all. It just goes to show you that when life is on the line, the gloves are off, whether it's loss of life through death or loss of life through freedom. When that time comes, it's every man for himself.
I knew we was going to war with China, so I've been prepared. I thought I was going to have to go to war with niggas, but I've been waiting for this, China. And it's in the back. I've been waiting for this.
You are now tuned in to the latest YouTube channel in the world. Yeah.